Alrighty, everybody. One day, there will be a day when there will not be a Fani Willis update to update the world on. Today is not that day. There is an update in the Fani Willis case, and I've got to say, it's making my prediction that Scott McAfee is going to disqualify Nathan Wade and Fani Willis all the more likely. And I do want to toot my own horn here, or pat myself on the back. I called this to some extent. When that RICO indictment came out back in August, I believe I referred to it as a steaming pile of judicial dog poop. And if any of you think I'm exaggerating, I referred to it as a steaming pile of judicial dog poop right along with the hashtag on Twitter. For those who haven't read it, rest assured, the Georgia indictment is a steaming pile of judicial dog poop. Anybody who says otherwise is a moron or a liar or a combination of both. Or a Democrat, sticking tongue out face emoji guy. Hashtag judicial dog poop. Now, why did I say that? Because the indictment was a steaming pile of judicial dog poop. One of the allegations in the indictment itself, let me go back and read it because it was in that tweet of the judicial dog poop. It says, and I quote, "On or about the 17th day of September 2021, Donald John Trump committed the felony offense of solicitation of violation of oath by public officer in violation of OCGA sections whatever in Fulton County, Georgia, by unlawfully soliciting, requesting, and importuning Georgia Secretary of State Brad Ratfaceberger, a public officer, to engage in conduct constituting the felony offense of violation of oath by public officer, OCGA and whatever sections, by unlawfully, quote, decertifying the election or whatever the correct legal remedy is and announce the true winner, end quote, in willful and intentional violation of the terms of the oath of said person as prescribed by law with intent that said person engage in said conduct. This was an overt act in furtherance of the conspiracy." The indictment was such a steaming pile of judicial dog poop, it actually alleged that Donald Trump broke the law by asking Raffensperger to do whatever the legal remedy is to ensure that the proper results of the election came through. He broke the law by asking, imploring, importuning Brad Raffensperger to do whatever the proper legal remedy is. Yes, you read it, in that steaming pile of judicial dog poop. And it seems that I was not the only one who believed that that indictment was a steaming pile of judicial dog poop, because a number of the defendants asked to strike a number of the charges, 6 of the indictments, and today, Scott McAfee, the judge who is currently deciding whether or not to disqualify Fani Willis and Nathan Wade, struck 6 of the indictments, 6 of the charges from that indictment. The defendants challenged counts 2, 5, 6, 23, 28, and 38 of the indictment by way of special demurrer. Demurrers provide a means for the criminally accused to ensure that the state's charging document satisfies the constitutional mandates of due process and the Sixth Amendment. Very simply put, because it's described in greater detail in the decision itself, a demurrer, I think it's of French origin, demurrer, to stay or to reside, but I don't actually know the legal French origin of the term, the etymology, whatever. A demurrer is basically like in civil law, if people make allegations that are sufficiently vague that you don't actually know what you're defending against. In civil law, at least in Quebec, when I was a practicing attorney, you could ask for a motion for specifics, a motion for details, provide some details so that I know what exactly you're accusing me of in this civil case. There's a criminal equivalent. It's called a demurrer, to strike accusations, to strike charges that are so vague that the defendant doesn't actually know what specifically is being accused of them, so that they are incapable of providing a defense. And in this case, the defendants are saying in these 6 charges in the indictment, they're vaguely alleging that we solicited, importuned people to violate their oath of office. The defendants sought the dismissal of the charges on 2 grounds. On the one hand, they allege that the indictment didn't specify what oath of office is alleged to have been violated. Judge Scott McAfee came to the conclusion that there can only be 2 oath of offices here. One is an oath to the Constitution. The other one is the oath to the Constitution of the state of Georgia. So although they don't specify what specific oath they were alleged to have importuned to violate, that it's pretty clear which oaths that they're talking about, but that it's not clear which provisions of these oaths they are talking about, because they're talking about the U.S. Constitution and the Constitution of the state of Georgia. And like Scott McAfee rightly observes, there's a lot in those oaths. There are many, many amendments, and some scholars have devoted their lives to one specific amendment of those respective oaths. And although it says, yeah, they importuned people to violate their oaths, they don't mention which provisions, which amendments, which articles of those oaths they were alleged to have been encouraged to violate. Our appellate courts have provided a well-used standard for evaluating a special demurrer. The test is not whether the indictment could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet, and, in case any other proceedings are taken against him for a similar offense, whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. And just to give one example of one of the charges in the indictment and the vagueness of this particular charge, I'll read one in particular, but they're all mutatis mutandis, pretty much the same. Count 5 alleges that defendant Trump solicited the Speaker of the Georgia House of Representatives to violate his oath of office on December 7, 2020, by requesting or importuning him to call a special session to unlawfully appoint presidential electors. The 6 impugned charges are all drafted virtually identically in terms of the vagueness of the oath of office, the random provision that they were encouraged, importuned to violate, but this is what the judge says as relates to not specifying which provision of their oath of office they were alleged to have been importuned to violate. On its own, the United States Constitution contains hundreds of clauses, any one of which can be the subject of a lifetime study. Academics and litigators devote their entire careers to the specialization of a single amendment. To further complicate the matter, the Georgia Constitution is not a, quote, mere shadow, end quote, of its federal counterpart, and although some provisions feature similar language, the Georgia Constitution has been interpreted to contain dramatically different meanings. What I especially love about that astute observation by Judge McAfee is that there are a great many constitutional scholars who have dedicated their lives to studying the Constitution, such as Lawrence Tribe, who just had his butt handed to him by 9 Supreme Court justices. Apparently, he needs to better dedicate his life to understanding the Constitution, but I digress. The court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged an abundance. However, the lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. So Scott McAfee, who's currently deciding whether or not to disqualify Fani Willis and Nathan Wade, has decided that 6 of the 41 charges in the indictment need to be tossed under this special demurrer because they are sufficiently vague, such that the defendants really don't even know how to defend themselves against the accusations. In one of the footnotes, the judge goes over the recourse, the remedies that the state might have in terms of refiling an amended indictment or reconvening the special grand jury. From what I understand, there are basically 3 courses of action. The state can appeal this decision, do nothing with it, and move the file forward with those 6 charges not included in it, or they can resubmit an amended indictment to try to cure it of its defects. My prediction is I don't know if Fani Willis can do anything until the judge decides on her disqualification. My prediction is that she does get disqualified, so whatever new DA comes in to take over this steaming pile of judicial dog poop of an indictment will make that decision at that time. This is all crumbling faster than dried brownies, than a crumbling cookie. This is coming down faster than a house of cards that was made with dollar store glue. But most importantly, as relates to my prediction that Scott McAfee disqualifies the 2 of them, I think he's laying the groundwork now to show them that he is not afraid of making decisions that might be politically unpopular, although I do dare say that justice one day in the near future might be politically popular and we might be on our way to that day. But that being said, I will obviously be following this. I will obviously come to you as soon as there's a decision on the motion to disqualify. If you like what I do, you know what to do. Like, share, subscribe. Viva Frei on Rumble, the Viva Frei on Twitter, vivabarneslaw.locals.com on Locals with my partner-in-law, Robert Barnes. We'll be talking about this Sunday night, sure as sugar during our Sunday nights, Law for the People extravaganzas. Most importantly, get out there. The days are an hour longer. Sunlight, exercise, eat healthy, talk to people in real life, and now you know you're wrong. Peace out, peeps.